Hello, and in this video I'm going to talk you through how you can master reading time, how you can use your reading time in the best way possible. Now reading time is really important because you've got 15 minutes of it before your 2-hour exam. So you need to be able to use this reading time to act as a bit of a starting block for your exam. Okay, so if you use that 15 minutes really well, then you're going to get a really good head start in the exam. Now we do use reading time in the SACs as well, and what we see kind of at the moment is people, they read the questions for 1 or 2 minutes, and then it ends up being a little bit like this. They kind of sit there for the rest of the time, staring, waiting for the reading time to be over, and that's not how we want to use our reading time, because it is a really important thing for you to do effectively. So instead, we really want you to end up like this, okay, like a running race with a couple of hurdles involved. It's all about the start. It's all about using those starting blocks to get you off to the best start possible. Okay, it is a launching pad. So that is what we want you to do with your reading time. So these are the 3 steps that I'm going to follow. Now, you don't have to follow these 3 steps, but hopefully they give you an idea about a way that you can use your reading time in a way that works for you. So what I'm going to do is, first of all, I'm going to do an exam reading time practice with you. Okay, so I'm going to kind of do it, I'm going to talk you through it, and these are the 3 steps that I'm going to follow. The first time I read through the exam is going to be to quickly focus on each question. So give myself about 5 or 10 seconds on each question, thinking about how I'm going to answer it and any content that jumps to mind. I'm also going to be reading through the source material on this first reading. Okay? I'm going to read through the source material slowly and paint a picture in my mind so I actually know what the source material is about, what's happened in the scenarios, and what some of the different non-scenario material is. Once I've done all that, I'll go back and on my second reading, I'll put in place time checks. Now this is going to be a quite quick process of me figuring out essentially where the 30-minute places are in the exam. So every 30 minutes, I want to check to make sure that I am on track to finish my exam. One of the biggest mistakes people make in exams is they run out of time. And if you run out of time, you lose easy marks. So you want to make sure that you're on track throughout the exam. So by putting in time checks, you're checking every 30 minutes to make sure you are at where you want to be. And if you're behind, then you know that you need to kind of pick up the pace in the next half hour. Then I'll go back to the start again, and I'll start to develop my answers. So on the third reading, I'll actually start to think about how exactly am I going to structure it and what exactly am I going to write. Therefore, when the examiner says that writing time begins, I'm ready to go straight away, and I'm writing from the very beginning. So those are the 3 steps I'm going to do. I'm going to use a practice exam. I haven't looked at this practice exam before. I've opened it up. So I'm going to talk you through my thinking as I go through it. I'm probably going to make some mistakes in what I read and in the content knowledge. That's okay. It is my first time looking at it. So hopefully it's kind of it's a natural way for me to do this. Now, as I go through, I want you to think about it as well. So even though I'm going to be reading out and talking you through my process, I want you to think about what you're thinking about when you see those questions. So, what answers come to your mind? What way do you think you should structure the answer? Okay, and then you can kind of listen to what I'm saying. Think about the way that you would do it and find a way that works best for you. So without further ado, let's get into the exam and we'll start our reading time now. So I'm going to scroll down to the first question. First of all, I know there's 80 marks, 40 marks in each question. So I know it's 1.5 minutes per mark. First case scenario. Tyson, aged 24 years, has been charged under Section 79A of the Crimes Act 1958 with aggravated carjacking after threatening a driver at gunpoint and using force to steal their motor vehicle. He has been denied bail prior to committal proceedings. Okay, stay with Tyson has been charged with a summary offence or an indictable offence. Okay, so I'm looking for evidence committal proceedings. Committal proceedings only happen in indictable offences. So there's some evidence. I know that it's an indictable case. Provide one reason for your decision because it says committal proceedings. Discuss the extent to which one purpose of committal proceedings can be achieved. Okay, the purpose of committal proceedings is to determine if there's a prima facie case. So it's a discuss question. Only 3 marks though. So a positive and a way that that this purpose is achieved, and a way that this purpose isn't achieved, and maybe a little bit more explanation, or maybe a third point as well. Evaluate the extent to which the separation of legislative, executive, and judicial powers act as a check on Parliament in lawmaking. Okay, and evaluate question 5 marks. So 4 marks for my points, 1 mark for a reasoned conclusion, and I need to make sure there's positive and negatives in there as well. So the legislative and executive, well, they are independent of the judicial powers. However, the legislative and executive kind of overlap as well. So that doesn't really allow them to act as a check in lawmaking. Okay, so I've got a couple of ideas. State one High Court case that has had an impact on the division of constitutional lawmaking powers. Tasmanian Dam case. Explain how the case stated in Part A has impacted on the division of the constitutional lawmaking powers. Well, it's where Section 109 came in and said that the federal parliament has the right to make laws about international treaties, and I can talk about that for a little bit. 3 marks, so kind of identifying the way, going into more depth about it, and then giving an example would get me those 3 marks. Malcolm is a 19-year-old student who works part-time in a bakery. On his way home from work one night, he lost control of his motor vehicle and collided with a cyclist. Oh dear. Malcolm was speeding at the time of the incident and was charged with dangerous driving causing serious injury. Malcolm is worried about his case because he knows very little about the legal system. Well, I think legal aid will be able to be helpful here. And he believes he cannot afford legal representation. Okay. With reference to one principle of justice, explain why it is important for Malcolm to seek legal advice. Okay, so I already said there's 2 parts to this question. That's the first part, explaining why it is important for Malcolm to seek legal advice with reference to a principle of justice. Equality is probably the principle of justice I go to the easiest because it allows Malcolm to be on equal footing with the prosecution. Discuss how Victoria Legal Aid might be able to assist him. So this is probably going to be worth the other 4 marks in the question. I want to give a couple of positives and a couple of negatives. That's probably the easiest way for how VLA can assist him. So they can provide legal representation. However, if he doesn't meet the eligibility requirements, then they can't really help him to a full extent. Okay, let's move on. Explain one benefit of having the Victorian courts arranged in a hierarchy in this case. The word that popped into my head straight away there is appeals. So I'm going to explain appeals and go into a bit more depth. Scroll back up. Explain how Section 109 of the Australian Constitution affects the legislative power of state parliaments. 3 marks. Okay, so I know that Section 109 restricts the state powers because they can only legislate in areas of residual and concurrent powers. So that's what I'm going to explain. Again, explain so an example is a good idea to get the full marks. George rents a small house from Amal. Under the terms of the rental lease, Amal, as the landlord, is required to carry out necessary repairs to reasonably maintain the property. One night a large storm damages the front gate, which now does not close, and cracked 3 windows in the rental property. George has contacted Amal several times requesting she repair the front gate and the windows, which she believes are unsafe, and she is unwilling to do so. George does not wish to take the matter to court, but definitely wants Amal to be compelled or ordered to undertake the repairs. Okay, explain why CAV and VCAT might both be appropriate bodies to resolve George's dispute. Okay, we've got 5 marks. I think I can break down this question into 2 parts. Explain why CAV might be appropriate for George and why VCAT might be appropriate for George. So those are the 2 parts. So one part can be 2 marks, one part can be the 3 marks. Just some ideas off the top of my head. It's more relaxed, and they don't want to bind, or George doesn't want to bind any decision. So both of them would be appropriate, or especially, sorry, CAV would be appropriate for that. VCAT not as much, but that's a point I can make for CAV. Discuss the extent to which, it's a 10 marker, oh dear. Discuss the extent to which Parliament is able to respond to the need for law change. Support your response with the explanation of one parliamentary committee or one royal commission. Okay, well, we looked at one royal commission, so that's okay. And a discussion of its ability to influence law reform. So I can talk about the Royal Commission into Aged Care. And then I need to discuss the extent to which Parliament is able to respond to the need for law change. I guess there's, again, 2 parts to this question. Probably half of it is the first sentence. So I need to discuss how Parliament can respond to the need for law change. And then in the second part, of course, using the example of the Aged Care Royal Commission, discuss that commission's ability to influence law reform. So those are the 2 parts to that question. Okay, I really need to hurry up so I can use the best of my reading time. Okay, we're into section B now. I know I need to reference the source material in each question. And the source material here isn't a case scenario. It seems to be out of some kind of document. And it's out of the Victorian Law Reform Commission Act, access to justice litigation funding and group proceedings. So I think this is a reference to for the VLRC to investigate this issue of justice litigation funding and group proceedings. The Victorian Law Reform Commission is asked to report on the following issues to ensure that litigants who are seeking to enforce their rights using the services of litigation funders and or through group proceedings or class action lawsuits are not exposed to unfair risks or disproportionate cost burdens. Okay, so I know the VLRC investigated this issue, so I guess this is just the document that required them to investigate. And then source 2 is a bit from the website. Okay, and this must be their final report, maybe. So there's a link to their final report once they'd done the investigation. So this will be their findings on litigation funding group proceedings. So I just need to reference that in my answers. In March 2018, the VLRC completed its report, Access to Justice Litigation Funding and Group Proceedings. The report contained a range of recommendations to improve access to the civil justice system for those litigants who use the services of litigation funders or participate in representative proceedings. Define the term representative proceedings. Okay, talk about class actions, 7 or more people. Explain the role of VLRC and discuss its ability to influence law reform. Okay, so it's a big 7 marks, probably 3 marks for the explanation, 4 marks for discussing its ability to influence law reform. So let's keep going. Explain one factor that can limit the ability of an individual to access the civil justice system. Okay, so this is talking about cost or time or accessibility. I need to link it to the case, the source material, so I can talk about how doing class action lawsuits will save the individual time because they don't have to be at court to undertake the action. That's probably going to be part of my answer. Question 2. In August 2017, the owner of a vineyard was awarded damages after Supreme Court Judge Justice John Dixon found the defendant had carelessly sprayed his land with toxic chemicals that drifted onto the plaintiff's property and destroyed the grapevines. He was ordered to pay 6.5 million for economic losses. Okay, so that's specific damages. The cost of re-establishing the vineyard and loss of future earnings. Future earnings is general damages. Okay. Other than costs, explain two factors the plaintiff might have considered when initiating his civil claim. Okay, so cleanse, but not costs. So any of the other four limitation of actions, blah 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 blah. Explain two of them. So state what it is and go into a bit more depth on each of those. It's going to be 4 marks. A number of civil pretrial procedures took place in this case. Describe two main purposes of civil pretrial procedures. Use examples to support your response. So civil pretrial procedures there, the purposes are to inform both parties of the information of both sides, as well as to set a timeline for the case. So those are two main purposes. I just need to be able to go into a bit more depth and use examples from this case scenario, the grapevine vineyard one, to get me the 4 marks. Discuss the responsibilities of the judge, Justice Dixon, in this case. Okay, so what are the good things about his responsibilities? What are the limitations on his responsibilities? We know that he, if there's a jury, he needs to take care of jury matters, but his main role is to come to a decision on liability and to come to a decision on damages. So I need to talk about what the good things are there and then what the limitations are. Describe the remedy awarded in this case, that was damages, and discuss the extent to which it could be able to achieve its purpose. Okay, so I can talk about specific damages are able to achieve its purpose because it's able to directly compensate the victim for their loss. However, general damages obviously aren't specific and may not be able to fully compensate the victim, as well as emotional trauma. I can talk a bit about that as well. Lots to talk about. Okay, I see the word Marbo. That's good. I know the Marbo case. The decision was to grant, blah, blah, I know about that. In making its ruling in this case, it is widely acknowledged that the justices of the High Court were activists in their approach to legally recognising the rights of Indigenous Australians to make claims over the traditional land. Describe judicial conservatism and judicial activism. So, definition, link to Mabo, definition, link to Mabo. Discuss how the doctrine of precedent and the requirement for standing are able to affect the ability of courts to make law. Okay, so again, I can break this into 2 parts, 3 marks for each part. Discuss the doctrine of precedent and how that affects the ability of the courts to make law, and discuss the requirement of standing and their ability, their effect on the ability of the courts to make law. Okay, I think that's going to be the end. Yes, it is. Okay, I'm running out of time, so I want to move on to stage 2 of my reading process, and that is to put in time restraints. Now, after every 30 minutes, I want to see where I'm up to. So I know that because there's 80 marks and it goes over 2 hours, then 20 marks should be a half hour's worth. So I'm going to just note where the half hour mark is in this exam. So first of all, I need to count to get to 25. What was that one? 10, 14, 20. Perfect. So at the end of page 6, I want to have completed page 6 by the end of that first 30 minutes. So the 30-minute mark, I'm going to check. Hopefully, I'm beyond page 6. If not, I'm going to have to hurry up. If I'm beyond it, very good. Sorry, what am I doing? Another 20 marks. In fact, I know that the next 20 marks is going to finish at the end of section A, okay, because there's 40 marks. So section A will be the second half hour, and then section B, the next half hour, will be finished at 1, 8, 12, 16, 20. Okay, so the end of page 16. Okay, so the end of page 6, is where I should be passed at the first half hour. End of page 16 is where I should be at the end of the third half hour. Okay, so one of the first things I'm going to do when the examiner says that writing time begins, I'm going to put just a little star or a little mark at the end of page 16, the end of page 6, and probably at the end of section A, just to indicate myself that I want to check the time and see where I'm at. This will allow me to make sure that I'm on track throughout the exam. Now, I know I've kind of exhausted my reading time now, but obviously I've had to talk you through it a little bit, talk you through my thinking. So I'm going to just take another minute to go into step 3 of my process, and that is to think about exactly what I'm going to write. State whether Tyson has been charged with a summary offence or an indictable offence. Okay, this one's pretty easy. Tyson has been charged with an indictable offence. We can see this because the case contains committal proceedings, and committal proceedings only occur in an indictable offence. So that's exactly what I'm going to write for that question. Discuss the extent to which one purpose of the committal proceedings can be achieved. So the purpose of determining if there's a prima facie case can be achieved because the judge gets an outline, or the magistrate gets an outline of the whole case, so it can give an informed decision. However, because not all of the evidence is discussed in great detail, the magistrate might not be able to give an accurate indication of whether there is a prima facie case. So there's 2 marks. I'll probably have to get a 3rd mark. I could do that by giving an example. So maybe I'll use this as my example. So for example, Tyson, let me think. So I told you I wouldn't be able to do this very easily. So my 3rd mark, anyway, I want to use Tyson in my example. I want to reference that. If I do that well enough, I can get myself the 3rd mark. Okay, so those are the 3 steps. I read through it to focus on each question just very quickly, figure out where the marks are, figure out some of the terms that pop into my head, and to read through the source material in detail. The 2nd step, put in place time checks. 3rd step is to start actually thinking about exactly what I'm going to write, so I can get started straight away, so I can be like the runners. Okay, so I can take off very quickly at the start of the exam. So I know it did take me a little bit over 15 minutes to actually get through that, but hopefully this has been beneficial for you in thinking about how you can use reading time to the best of your ability, because I really want you to be able to get a head start in that exam. Okay, when other people from other schools are wasting their reading time, okay, I want you to be able to use it as effectively as possible. So even if it's not exactly my 3-step process, think of the process that works for you, and hopefully this will prove beneficial when it comes time for the exam.